It's your boy Street Cred, 4K, all day, back like I never left. Listen, there's some more deep fried cooking popping off with Big U, but we know that. I said the last video that Big U was deep fried cooked, and I'm gonna say it right now. It seems like not only he is cooked deep fried Southern style, but his co-defendants, Loose Cannon, Brick Baby, is right there along with him. But we're going to jump right into it because their trial has been postponed. It's been pushed out. They've been given, that seemed like the feds want to give it some more time. And it seemed like the co-defendants want to give it some more time too, about an entire year. It's supposed to be, they set to go to trial. They were set to go to trial May 9th, right, of this year. Now they set the trial for I believe May 4th of 2026. And you know what? The co-defendants want that. The federales want that, but Big U doesn't want that.
Request for continuation of trial date and findings of excludable time periods pursuant to the Speedy Trial Act. And so the document says plaintiff, United States of America, by and through its counsel of records, and defendants Sylvester Robinson, Mark Martin, Tremaine Williams, Armani Elefe, Frederick Blanton Jr., and Tiffany Shanika Hines, all individually and by and through their counsels of records, respectfully hereby stipulate as follows. The indictment in this case was filed on March 26, 2025. Defendants Robinson, Martin, this chick Blanton, and Hines first appeared before a judicial officer of the court in which the charges in this case were pending on March 19th, 2025. The Speedy Trial Act originally required that the trial commence on or before June 4th, 2025 as to those defendants. Defendant Henley first appeared before judicial officer of the court in which the charges in this case were pending on March 20th, 2025, and the Speedy Trial Act thus originally required that the trial commence on or before June 4th, 2025 as to that defendant. Defendant Williams, this is Loose Cannon, first appeared before a judicial officer of the court in which the charges in this case were pending on April 4th, 2025. The Speedy Trial Act thus originally required that the trial commence on or before June 13th, 2025. On April 4th, 2025, the court set a trial date of March 19th, 2025, and a pretrial conference of May 9th, 2025 as to the defendant Loose Cannon. On April 18th and 14th, 2025, the court set a trial date of May 20th, 2025, and pretrial conference for May 9th for all other defendants. Defendants Henley and Williams are detained pending trial. Henley is Big U, Williams again is Loose Cannon. The remaining defendants are on bond pending trial. The parties estimate that the trial in this matter will last approximately 12 days. By this stipulation, defendants move to continue the trial date to May 4th, 2026 and the pretrial conference date to April 24th, 2026. This is the first request for a continuation. Defendants request the continuance based upon the following facts. Defendants are charged with varying violations of 18 U.S.C. 1962, the Racketeer Influence and Corrupt Organizations Conspiracy Act, and conspiracy to interfere with commerce by robbery and extortion, interference with commerce by robbery and extortion, transportation of an individual in interstate commerce with the intent that that individual engage in prostitution, wire fraud, embezzlement, conversion, and international misapplication of funds from organization receiving federal funds, bank fraud, attempt to evade and defeat the assessment and payment of income tax, willful failure to file a tax return, and the government has produced over 60 gigabytes of discovery to the defense, including law enforcement reports, certain returns, criminal history documents, recordings, and photographs. The government is in the process of producing over 20,000 intercepted audio calls, as well as numerous surreptitious audio and video recordings, much of which will be protected discovery. The government sent defense counsel a stipulation for a protective order.
Over 60 gigabytes and 20,000 wiretap calls. You know what? We watching a modern day mob situation play out. You know, like when they catch Gotti, when they catch one of them boys, you know what I mean? And they really and they pull the blankets back and they see what's really going on over there. I mean, this is some real live. And the way they're able to use technology and the internet and these podcasts and these no jumpers and all of that to set them boys up these days, Big U didn't have a chance. Loose Cannon, who's defended Williams, didn't have a chance. They don't have a fighting chance that the old school gangsters had. because there's too many cameras everywhere. There's podcasts and people like to go and clout chase and get clout for what they doing in these streets, which is, if you a gangster, which is the absolute opposite of what you should be doing. But to each his own. Because like I said, if Big U has any connection to Nipsey's murder, this is that deep fry process that's supposed to be happening. That's going to, uncover everything that needs to cover. That's going to connect. Hopefully, possibly, allegedly connect to something. Because again, when you're doing this type of stuff out there, and you in these streets, and you running wild like that, and you're supposed to be the leader of the Rolling 60 Crips, I would think that you'd be on the phone a whole lot less than allowing them to be able to wiretap 20,000 intercepted calls. That's a lot of calls, man. I don't know what kind of pillow talking really going on with that many. With 20,000 calls. That's to me that's bizarre. That's insane. All I know is that if I was in those types of shoes, which I would never be, if I was in them types of shoes, I wouldn't even be on the phone. I would have known the feds obviously watching me. I mean, you got to be next level dumb to not know that they got your phone tapped. With all the technology they have these day and age, they can just tap right into the system. So it's getting worse and worse. When them feds stretch that thing out and say, we're not going to have enough time to get this done around this time. Look, if they really want to get somebody bad enough, they're going to do it at the time that they want to do it at, right? But they're not going to give Big U what he wants because they know why he wants it. And him being so eager to run the trial when he's facing 600 years shows them something. It shows the feds that there's more skeletons in the closet. I mean, there's some more things up under their blanket they got to pull back. I mean, there's some more layers they got to peel back. There's more things they got to unpack. That's what it shows the feds. And they're able to say, look, we got other cases that's more important to take care of, that's very timely, and we need more time to prepare. Now, this absolutely happens in all cases and in Fed cases, but, not just too long ago, they was all ready to go to trial, I believe, May 9th of this year, right? And all of a sudden, co-defendants, people start saying things, not saying that anybody's quite talking yet, but they may have some notion that they may have some motion that somebody is about to crack, that somebody is about to break, and somebody gonna bust wide open. And so, give them a year to sit for a little while to find out how horrible it is in the feds, and somebody gonna break. And it's gonna just make it that much more easier for them to drop you, Big U, deep in that frying basket. That's what they doing. That's what they doing. I mean, I may have seen a couple cases get fought, in my time, and so I have an idea of kind of how these guys do things, but yeah. They really taking time and prepping them up with all the fixings and all the seasonings, and so that when they do drop them in that deep fry oil, that he come up well done and ready to serve, and there's no way out of that.
While defense counsel for Big U notes that defendant Big U objects to any continuances, defense counsel represents that he is presently scheduled to be in the trials listed in the document attached to this filing as Exhibit A, as well as various other matters. Defense counsel for defendant Robinson is presently scheduled to be in the below described trials, as well as various other matters. And then they list out all of the trials that Robinson's attorney is going to be involved in. I think Big U's attorney is going to be involved in some of these too, right? And the reason they're laying these out is to say, hey, look, we're busy. We're not going to be able to do this trial at this time. We have other cases that we are working on. And so that goes on for a few pages, right? I'm not going to read every case that they're going to be involved in because it's just a bunch of details that have nothing to do with Big U or with the rolling 60s. So it says, accordingly, counsel represents that they will not have the time that they believe is necessary to prepare and be available to try this case on the current trial date. In light of the foregoing, counsel for defendants also represent that additional time is necessary to confer with defendants, conducting complete and independent investigation of the case, conducting complete additional legal research, including for potential pretrial motions, review the discovery and potential evidence in the case, and prepare for the trial in the event that a pretrial resolution does not occur. Defense counsel represents that the failure to grant the continuance would deny them reasonable time necessary for effective preparation, taking into account the exercise of due diligence. Right? So basically, they're saying all the defendants agree that even though they have the right to a speedy trial and it should start in May, the lawyers need time to prepare, time that they just don't have. So all of the defendants and the feds are requesting a continuance. But in K here, it says defendant Big U objects to continuing the trial in this matter. So he don't want it to be continued till next year. He's basically like, bro, y'all denied me bond. Y'all arrested me. Y'all got me in here. Either y'all got the evidence or y'all don't got the evidence. Put me on trial. I don't care if my attorney is prepared or not, which is crazy because Big U is facing 600 years. You would think that he wants his attorney to be as prepared as possible, but apparently not.
Maybe, just maybe, Big U believes his only chance of ever seeing the light of day, which, you know, not to pour salt in nobody's wound, but he ain't never gonna see the light of day. No matter what he thinks he's gonna do, he's never gonna see the light of day. And there's a good possibility defendant Williams, loose cannon, ain't never gonna see the light of day. It's a good possibility he ain't never gonna see the light of day. I think the only person who has a shot at ever seeing the light of day is possibly Brick Baby, and that's because he's really far down the line as far as chain of command goes in that whole case, right? So possibly Big U thinks that hurry up, rush this to trial. I know y'all gonna convict me for whatever y'all gonna get me on. His only shot at ever seeing the light of day is what he believes is possibly an appeal.
It says, nonetheless, the stipulating parties agree that pursuant to USC 3161, the time period of May 20th, 2025 to May 4th, 2026 constitutes a reasonable period of delay for defendant Big U, who is joined for trial with the co-defendant, as to whom the time for trial has not run and no motion for severance has been granted. The other defendants, however, believe that failure to grant the continuance will deny them continuity of counsel and adequate representation. The government does not object to a continuance. The requested continuance is not based on congestion of the court's calendar, lack of diligent preparation on part of the attorneys for the government or for the defense, or failure on the part of the attorney for the government to obtain available witnesses. So they're saying that they have all that. This continuation isn't because of any of that. It's simply because the attorneys feel like they wouldn't be able to represent their clients to their fullest ability if they go to trial on May 9th. It says, for purposes of computing the date under the Speedy Trial Act by which defendant's trial must commence, the parties agree that the time period of May 20th to May 4th, 2026 inclusive should be excluded pursuant to 18 USC. So basically they're saying that you take that year, cut it out. It's like it never happened. Everybody except Big U is agreeing that that delay is necessary. It says, because the delay results from a continuance granted by the courts at the defendant's request without government objection on the basis of the court's finding that the ends of justice served by continuance outweigh the best interest of the public and defendants in a speedy trial, and 2, failure to grant the continuance would likely make a continuation of the proceedings impossible or result in the miscarriage of justice, and 3, failure to grant the continuance would unreasonably deny defendants continuity of counsel and would deny defense counsel the reasonable time necessary for effective preparation, take into account the exercise of due diligence. Nothing in this stipulation shall preclude a finding that other provisions of the Speedy Trial Act dictate that additional time periods be excluded from the period within which the trial must commence. Moreover, the same provisions and other provisions of the Speedy Trial Act may in the future authorize the exclusion of additional time periods from the period in which the trial must commence. Basically, they're saying if it is delayed, everybody is agreeing that they are not going to say this violated their right to a speedy trial.
Basically, the judge said, F you, Big U, we don't care what you want. We gonna cook you how we cook you. We're going to deep fry you how we deep fry you. You don't have no say-so in how we deep fry you or what seasonings we use or how long we let that flour poof poof and move you around in there so that we can get you all fixed up and get ready to drop you in. We stretching this trial out to next year of 2026. So you're going to sit in here for a while just in limbo. And we're going to give time for your defendants to break. Because that's what's happening. Just give them time to break. Give them time to start talking. Give them time to do whatever it is that they're going to do. And we're going to find out the real deal about you and what you really been up to other than what we haven't already discovered in them 60 gigabytes of information. How much 60 gigabytes is? 60 gigabytes, that's a lot of gigabytes of information. That 20,000, that's a lot. 20,000 is a lot of intercepted calls. I mean, just imagine what's about to unfold. Yeah, it's your boy Street Cred 4K. Keep it locked. Stay checking in. Keep tapping in. That's the update. The trial for Big U is not going to happen till next year, but there's going to be a whole bunch of interesting things that's going to unfold in that time. And apparently, there might be some unsolved murders out there. Don't know if that's linked back to Big U or not. All I know is that it's getting more and more wild, and we're watching a modern day mob gangster movie play out, and with these sort of modern day type of figures that happen to be gang members from the rolling 60s. All right, so do your boy a favor, like, share, subscribe, keep tapping in, keep checking in, and I'm gonna keep bringing you the truth.